All right, ladies and gentlemen, let's get into our final lecture for Sociology 327. We're going to be looking at punishment, both our first and second lecture on it. So, yeah, let's get into it. Right, we're going to be looking at sentencing and punishment. Let's introduce this. Right, an introduction to sentencing and punishment. Punishment of convicted criminals is a complex and contentious issue. We have a couple of guiding questions behind punishment, right? What is a deserved punishment for a given crime? Can punishment deter future crimes? How do we determine rehabilitation potential through our means of punishment? And what should be the primary purpose of sentencing and punishment, right? Let's look at pre-sentencing reports. So, um, yeah, judges rely heavily on pre-sentencing reports prepared by probation officers. Reports are used in 61% of all serious offenses, like assault, whatever it may be. Hagen, and Bolt and others said that judges use these pre-sentencing report recommendations 80% of the time. What is a pre-sentencing report? It is a document prepared by the probation officer to provide the court with information about an offender's background and circumstances before they sentence. Right. Rationale for sentencing. Right. What is the rationale behind this? Behind our sentencing? Well, in the U.S., the U.K., and Canada, according to Roberts, who looked at public opinion, he said that many people from these places believe punishments are not harsh enough. U.S. respondents said that 53% of them said that the aim of sentencing is appropriate punishment. 21% said that the aim is rehabilitation. 13% said that the aim is deterrence and incapacitation, and 9% believe rehabilitation is impossible for offenders. Yeah. This is a little bit of public opinion we'll look at. But more importantly, let's look at these 6 rationales for sentencing. 1, we have deterrence, right? We sentence because we want to discourage future crimes. 2, selective incapacitation. We want to remove offenders from society. 3, rehabilitation. Right, we want to reform the offender. 4, the justice model, right? Fairness and consistency in sentencing is important. 5, restoration. We want to repair harm to victims and the community. And 6, healing. We sentence to address broader harm. We see a lot of this in indigenous sentencing circle contexts. So again, the 6 rationales for sentencing: deterrence, selective incapacitation, rehabilitation, the justice model, restoration, and healing. Sentencing determination, right? In determining a sentence, the judge considers legal restrictions, but also the mitigating circumstances to a sentence, right? The things that reduce severity of the sentence, and aggravating circumstances in sentencing, the things that would increase the severity of the sentence. We'll look at a couple of each of these here. So, for example, aggravated circumstances would be your previous convictions, gang activity, victim vulnerability, planning and organization of crime, multiple criminal offenses, using a weapon, brutality. Mitigating circumstances would be like being a first-time offender, based on the assumption that if you dissuade this person from crime by getting the right penalty, you can move them away from a life of crime and keep it at a one-time offense. Right. This is the first-time offender mitigation. You'll look at their employment record, right? If they can hold a job, that'll be mitigating. Efforts at rehabilitation, disadvantaged backgrounds, their guilty plea and an expression of remorse, the length of their prosecution time, and demonstration of good character. This is demonstrated by, a lack of criminal record, charitability, and volunteering efforts, having people vouch for you, whatever it may be. These are our sentencing determinations, right? Mitigating and aggravated circumstances. Judicial sentencing influences, right? What governs judging? What influences the sentencing? So 1, statutory direction, or what the law says. 2, guiding rules and principles. These help with appropriate dispositions by the judges. And 3, the personal characteristics of the judges. Individual perspectives and discretion, right? Discretion plays a big part in this. These are different judicial sentencing influences. Sentencing across land masses usually vary, right? In Canada, sentencing varies. For example, in PEI, drunk driving leads to incarceration, which is 30% of crimes. it can be jurisdictional, right? But generally, the three main factors: situational direction or statutory direction, guiding rules and principles, and personal characteristics of the judge, with a little bit of regional variation. Sentencing options. What can come of a sentencing? Things like imprisonment, intermittent sentences, like weekends being in custody, fines, restitutions and community service, probation, community-based sanctions, whatever it may be, right? These are our sentencing options. We looked at some sentencing decisions, specifically in 2011-2012. In 2011-2012, we looked at 386,500 cases in total. 64% were found guilty. 32% of those cases were withdrawn. 3% were acquitted, and 1% were other decisions. The outcomes of the guilty cases, though, those 64% guilty cases, saw 35% imprisonments, 52% other sentences, 3% conditional sentences, 45% probation, and 34% fines. So other sentencing, other than imprisonment, probation, conditional sentences, and fine, was the most common, while 45% saw probation as the second most common. Sentencing circles, what are these? Sentencing circles are alternative approaches to sentencing offenders, usually used, if at all, for property offenses. What are the benefits to this? It can reduce the monopoly of control by professionals over the process. It can encourage creative sentencing solutions, increase participation from accused and victims, and it can create a more constructive environment. Let's look at a few issues in sentencing consistency. So we're going to look at disparity as an issue, courthouse norms as an issue, sentencing discrimination as an issue, and public opinion as an issue. So disparity. This is a variation in sentencing, and this is often due to judicial discretion. Like we've talked about before, we want similar outcomes for similar behavior. Naturally, due to judicial discretion, you aren't always going to have that. The question is it the more lenient judges that are the problem or the more harsh ones? We don't know. Courthouse norms, another issue, right? Backlogs and reliance on plea bargains can see an issue in sentencing, right? Sentencing discrimination, right? Factors such as employment status and pre-trial detention can affect your outcomes in sentencing. And public opinion, right? 62% of the public and 63% of judges agree on which offenders deserve incarceration. However, not only does this lead to a large number of the population disagreeing with sentencing, which can lead to inconsistency, but also shows that public opinion can have a lot of sway in sentencing. So we went through the 6 rationales of sentencing, right? Deterrence, selective incapacitation, rehabilitation, the justice model, restoration, and healing. We looked at mitigating and aggravated circumstances. We looked at the 3 main factors governing judges, right? Statutory discretion, direction, guiding rules and principles, and personal characteristics of the judges. Different sentencing options. We looked at sentencing decisions and their outcomes of guilty cases, with 45% being probation and 52% being other sentences, being the highest ones. We looked at sentencing circles and what they're good for, and then we looked at the issues in sentencing consistency, making those issues being disparity, courthouse norms, sentencing discrimination, and public opinion. Now, punishment 2. This is kind of an elaboration on everything that we looked at, kind of using those fundamental concepts to really build upon the general idea here. So, to introduce the second one, let's look at Bill C-12. This is the Safe Streets and Communities Act. It was passed on March 12th of 2012. It was initiated by a conservative government, and it was rooted in the justice model. It introduced mandatory minimum sentences for drug trafficking, sex crimes, and child exploitation offenses. We're going to talk about mandatory minimum sentences for a while here. So, mandatory minimum sentences, or MMSs. This is the idea of essentially an automatic sentence at a minimum being established for doing a thing and committing a certain crime. This is promoted by politicians, arguing that the MMS system is a deterrent to crime. MMSs represent determinate sentencing. Again, like we said, an automatic sort of sentence where fixed penalties are established. MMSs are tied to truth in sentencing laws. Within truth in sentencing laws, there is an 85% requirement, essentially saying that individuals convicted of crimes serve a substantial portion, usually an 85% portion, of their prison sentences. So again, MMSs have a lot to do with truth in sentencing laws, which say that a convicted criminal should have to serve 85% of their prison sentence, at the very least. What are some critiques of MMSs? Well, the Canadian Bar Association's chair shared their perspective. The chair of the Bar Association argued that MMSs limit judicial discretion, reducing the ability of judges to impose sentences tailored to the nuances of individual cases. For example, judges would potentially lower a charge to a less severe one, even though the crime doesn't potentially deserve a less severe charge because of what might be an unfair minimum mandatory sentence for the higher charge, depending on the case. So they're kind of forced to pick, they're kind of stuck between a rock and a hard place, and usually to avoid a more harsh sentence that they don't feel is justified, is more unfair, they'll pick the lighter one, which also isn't good. Additionally, another criticism is the deterrence effect. It is argued that increasing the probability of being caught and punished is more effective than simply increasing penalties and the severity of the crime. So MMSs, automatic minimum sentences. Wrongful convictions. Let's take a look at that. So, what is the scope of the problem with wrongful convictions? Essentially, there is no systematic record of the number of wrongful convictions in Canada or the U.S., but Huff, a guy that we looked at in 1986, estimated that 0.5% of all felony convictions were incorrect. Naturally, this is a problem. 0.5% of felony or indictable offenses were wrongful. This is the equivalent of 5 innocent people per 1,000 felony convictions. And we see 34,250 wrongful convictions annually in the U.S. because of it, right? This is a problem. We don't want wrongful convictions. Naturally, we want justice served properly. So what causes wrongful convictions? Well, eyewitness error, forensic error, and misconduct by authorities are what causes wrongful convictions. We'll get into these, though. Eyewitness error is the most common reason for wrongful convictions. Why? Because of things like memory flaws, stress or trauma, and misidentification. Second one, forensic errors. I could get into the weeds of what exactly I mean, but essentially, let's look at this case. In the case of Dr. Charles Smith, essentially, this case itself highlights the flawed forensic practices leading to miscarriages of justice in some cases. So, Charles Smith was a coroner who dealt with children, typically deciding the child was killed or fell from a high chair, for example, He was singled out at having a rare expertise in this. The coroner's review of him found that he made questionable violations of foul play that led to criminal convictions, though. The government then ordered a public inquiry into his practice, and he was asked to perform a procedure. It was found that he didn't even know the basics of medicine. He was essentially just guessing at it. This is the problem with forensic analysis in murder and what that can lead to. Again, forensic errors. Many wrongful convictions come from forensic errors, and a lot of different wrongful convictions came from his forensic errors. And finally, along with eyewitness errors, forensic errors, we have misconduct by authorities. Overzealous or unethical actions by police and prosecutors can lead to wrongful convictions. Scheck and others found that 63% of wrongful convictions stem from a dysfunctional prosecutorial culture, or crown culture. Presumptive sentences. Let's define this, right? What are presumptive sentences? Presumptive sentences are essentially the same as sentencing guidelines. It is a method of sentencing providing judges with a range of minimum and maximum penalties based on the severity of the crime and the defendant's record. It is designed to eliminate judicial discretion based on the two factors above, which would hypothetically ensure consistency. So it's very similar to mandatory minimum sentences. But it's kind of establishing judges with a range of different minimum and maximum one based on the penalty, taking a look at two different factors, being crime severity and the defendant's prior record. What are the four purposes of presumptive sentencing? Uniformity, neutrality, truth in sentencing, and control. We'll go through these. So, uniformity in the system would ensure consistency across similar cases. Again, we want that. We want to make sure that different people, regardless of characteristic, except for those two variables we looked at, would be punished the same way for the same crime. Neutrality is the second one, right? This is preventing extra legal factors like race, socioeconomic status from influencing sentencing. Truth in sentencing, again, we looked at that. This is ensuring that what the offenders serve is the same as what the judge imposes. Part of that law, again, was the 85% rule. And control. This is the fourth purpose of presumptive sentencing, right? This is the aim to prevent overcrowding in prison. Just like who talked about that, overcrowding in prison? Was it Wilson? I think so. And I think we mentioned Wilson again here anyway. Either way, let's get into this. So the effects of presumptive sentencing, right? Meath and Moore found that presumptive sentencing and sentencing guidelines reduce judicial discretion and sentencing disparity, as they're intended to, shifted incarceration focus from property offenders to violent offenders. But again, like I said, remember, Wilson argued in Controlling Crime, that chapter, that you want the most amount of across-the-board criminals in prison, though serving averaged out sentences, right? So according to his perspective, this presumptive sentencing system actually works well, right? Shifting incarceration from property offenders to other way around. It doesn't agree with Wilson, because Wilson said that we should shift our focus from violent offenders more to property basic offenders. That way we can, reduce the sentencing of violent offenders, put more of the more common criminals in and increase their sentence, and generally reduce the amount of criminals on the street. So yeah, presumptive sentencing actually goes against what Wilson argued. And finally, another effect, along with reduced discretion and the shift of focus from property to violent offenders, is the impact on legal strategies. Sentencing guidelines, or presumptive sentencing, influence judges and prosecutors to by bending rules, and we never want that in the court of law, but adapt by bending rules during charge selection and plea bargaining negotiations. So again, they had to bend that rule because their discretion is limited. That is presumptive sentencing. Victim participation in sentencing. Let's take a look at that. Victim participation through victim impact statements are something that emerged in the 1980s to incorporate victim experiences and recognize their rights. The objectives of victim participation are to restore victim dignity, highlight personal impact of crime upon the victim, and enhance fairness in sentencing processes. The debate in victim participation is that victim participation threatens the adversarial system of the court, right? By adding in yet another factor, right? It may exert pressures on the judges. Having the victim there can potentially influence them. Victim participation involves vindictiveness in sentencing, right? There could be a level of revenge there rather than due process. And the participation has the potential to reduce the court's efficiency, right? You just have another piece there. But we have seen some legislative development within victim participation. The first Victims' Bill of Rights was made in Manitoba in 1986. The Victim Bill of Rights essentially achieves a version of victim participation, right? It gives victims a greater voice in the criminal justice system through a myriad of sections and rights in the courtroom and their court cases. Today, all provinces of the federal government have similar legislation to the Manitoba Victim Bill of Rights, though they vary. Mostly today, victim participation is used in sexual assault cases and cases of abuse. So a summary of key themes there. Sentencing is a contentious issue. The objective of punishment can often be contradictory, and judges possess great discretion, leading to variation in punishment across regions of cases. The justice model increasingly guides Canadian federal policy, with an emphasis on mandatory sentencing, reducing the role of judicial discretion, and strengthening victim participation through impact statements, with some judges leaning on this more than other judges do. And persistent issues with it, right? You got the risk of wrongful convictions, and sentencing reforms aim for consistency, but it can also provoke concerns about flexibility and justice. That is our lecture, SOCI 327 on punishment 1 and 2.